everyone doing? Good? I see some of you in suits. Does that mean a mock trial in moot court? Moot court. Is that today? Hopefully everyone is good. Good luck to everyone. Everyone advances, although all of you can advance, but hopefully as many of you advance as possible. Any questions about class from last time? Anything in your mind about zoning-based aesthetics, the First Amendment, or anything like that? Let's see. Nothing in your minds? Really? Okay. So today in class, we're going to continue the First Amendment with respect to free speech, and also move on to an aspect of zoning you probably never thought about, which is religious liberty. This is a topic that you may or may not have covered in con law, so you will get another mini review of that as well. Okay? No snickering. Okay. So the first case actually I want to talk about was decided like 4 months ago. It's so new, it's not even in your book. And the reason why I added this is this case, I think, affects a very significant change in free speech law with respect to signs. Now you're saying, Josh, what's the big deal about signs? Why do I care about signs? There is so much land use litigation that goes on based on signs. We had the Ledoux case last week. We have the Reed case this week. So much of what government tries to do is actually regulating what you can put on your business and what you can put on your home. So the cases we actually are discussing today are fairly good tests of how we feel about those decisions. Okay. So hopefully everyone had the PDF. It was short. It was only a few pages. This was actually from an undergraduate text, so it was a really easy edit, and they also summarize it. So there's no excuse not to know what happened. But our book does not have a excerpt of it yet. All right. What did I finish last time? Oh. Appreciate the candor. All right, Evan, so you can start off with Jimena. You're welcome to go next. All right, Jimena. I'm sorry, Evan. What were the facts in Reed v. Town of Gilbert, please?
Church, they didn't use community church, and they were putting up signs advertising when they were holding their services, and the city told them that they weren't allowed to do that anymore because they had a sign ordinance.
Okay, so before we get to the side ordinance, did this church have a fixed location?
No, they didn't have a building there.
So what were the purpose then of all these signs? Right. So imagine the situation here, right? You have a small church, not that many people, and every week you're in a different spot. You need to notify the people in your community of where service will be held this week. So, I mean, perhaps they could use Twitter. Maybe they can use a blog, but traditionally for a lot of people, the way you communicate information is by a good old-fashioned sign. You hold up a sign saying, today, on Sunday, service will be held at this location at this time. Now, Jimena, what about the sign ordinance in this town made that sort of advertisement difficult?
That it was temporary directional signs relating to a qualifying event was different than any other.
Okay, so a temporary directional sign, what the heck does that mean? What does this mean, temporary directional sign?
So it's when it defines temporary directional signs on the basis of whether a sign conveys a message of directing the public to church or some other qualifying event.
Okay, so in this case, this sign was clearly aimed at directing people to a specific event at church, right? Okay, so Michelle, what were the restrictions imposed on these temporary directional signs?
That they no more than 4 of the signs, 6
okay.
Maybe on single property at a time.
Uh-huh.
And maybe displayed no more than 12 hours before the qualifying, 1 hour after.
Okay. So here we're in a situation where, first of all, signs directing people to an event must be small, only 6 feet. That's not a very big sign if we're driving from a distance. But more importantly, Michelle, how long could the sign stay up?
1 hour after.
And how far in advance could they be put up? So everyone sees a problem here, right? If they're advertising a church service 12 hours before the church service, being Saturday night at midnight, okay, the sign will be absolutely impracticable to affect the change they want. They can't notify people. Further, within 1 hour afterwards, the sign must be removed. So basically, as soon as the service is over, you have to have someone drive around the entire town and scoop up all these services, right? I'm sorry, all these signs. This made it effectively impossible for the town to, for this church to advertise its services, okay? So before we get too far into the weeds, Natasha, if you were the lawyer for the city and you had to justify this ordinance, what is your best argument? If you're the city lawyer, you have to defend it. You can't do it. You can't say it's stupid, right? You're the city lawyer. You have to make some argument. What's your argument of why this law is necessary?
Well, you gotta use one of the four under the police power.
Yeah, good. Okay, so which aspect of the police power do you think this this ordinance would fall under?
And all of them.
Okay, how so?
Well, because the community would want, they have to be happy, and so this thing with visual clutter or anything.
Yeah, exactly, right? So the government comes in and they say, listen, we don't want clutter. We want to have our free and pristine streets. We want everything to be very nice and even, right? The problem, though, is based on how they evaluate the content of signs. So we discussed here these so-called temporary directional signs. Peter, there were two other categories of signs that the ordinance considered. What were these other categories of signs? Ideological signs and political signs. What the heck is an ideological sign and what is a political sign?
Ideological sign is a sign that expresses a certain belief.
Uh-huh.
A political sign would be, say, somebody running for office. And that's political.
Okay, so why do you think, and based on our discussion last class of the anti-war sign, why do you think the city attorney drew up this law with those exceptions in?
Because those things are, they do fall under freedom of speech.
Okay, so here the city was trying to do something good, right? They said if you have some sort of ideological sign or some sort of political sign, there are basically no restrictions, right? You can have a bigger sign, you can keep it out there longer, right? You can have a meaningful sign. But what they wanted to get rid of were these silly, a baked goods sale there, a quilt fair there, these sorts of signs that just promote clutter that aren't necessary. So we have here is a situation where there's two different sets of rules. For certain types of speeches, right? For certain types, they allowed them to stay up for a very long time. For other types of speech, for these directional signs, they can only be up there for 12 hours, and they had to have a much smaller size. Okay? Everyone get the facts. So Stephen, what do we do when a law restricts speech on the basis of its content? How does a court approach this? We discussed this last class. Strict scrutiny, what does that mean?
The state has to have
Okay, good. So under the standard of strict scrutiny, you usually look at two different things, right? What is the state's interest? It must be compelling. And can the state achieve that interest in a more narrowly tailored fashion? In other words, can they achieve the same interest of no clutter without roping in so much speech that's protected? Okay. Now, Stephen, how compelling is this clutter argument? How compelling is this argument for the city that they need to put this 12-hour limit on signs to get rid of clutter? Why is it not compelling?
because, like you said earlier, if it's placed there at midnight, it's only going to be there overnight. No one's going to be bothered by it.
But even more pressingly, how do we know that this interest isn't really that important to the city? What tells us by the statute itself that clutter actually doesn't bother them that much?
Because they allow the other side.
Exactly. Everyone understand that's an important point. The fact that they carved out an exception for other types of signs suggests that this interest in clutter isn't that important. It's like, oh, it's a sham, right? is a sham rationale. If the interest in clutter was actually that significant, they wouldn't have allowed any signs up for any period of time. The fact that they made exceptions, right? The fact that they made exceptions means their interest in getting rid of clutter is not indeed compelling. And that's really the crux of the first part of Justice Thomas's majority opinion. Justice Thomas explains, listen, if this is such an important interest, then why are they allowing all these other signs? You can't carve up exceptions for it. Okay? So the first part, discussion content neutrality, says if it's actually judging something on the basis of its content, which this law does, you apply strict scrutiny. Because for so many exceptions, this can't possibly be a compelling interest. You can achieve this in other ways. It fails strict scrutiny. Okay? But even more so, Ben, it violates something called viewpoint discrimination, which you may not have studied, but I think Justice Thomas explains in a very concise manner. What does viewpoint discrimination mean?
With the categorical, the ordinance is in categorical ways and the names of speech.
Well, specifically, what's viewpoint discrimination? It's not on the basis. It's not saying political signs, one rule, ideological signs, different rule, traffic rule, the third rule. What does viewpoint discrimination mean? What do you think the word viewpoint discrimination means? I mean, analyze the phrase.
My perspective.
Yeah, right? So imagine a law that said Democrats are allowed to speak in this public square, but Republicans are not. Right?
Discriminate against certain types of
Yes. It's discriminating against certain types of viewpoints, right? And Justice Thomas makes this point. If you have a political message, it goes one way. If an ideological message, it goes another way. So the example Thomas uses is like this. If you want to have a meeting about John Locke, a political scientist, a very famous philosopher, you have one set of rules. If you want to have a meeting about electing a politician who agrees with John Locke, you have a different set of rules. And if you have a sign directing people to where that John Locke meeting is, you have a third set of rules. So they're actually not only discriminating based on the content of the sign, but also in the viewpoint that you're espousing. And one of the canons of the First Amendment is that you cannot discriminate on the basis of viewpoint. You cannot favor one perspective over another. And this is what this law does very simply. Indeed, in Justice Kagan's concurring opinion, which is really more of a dissent, but in a concurring opinion, she has a great line. She says, this doesn't pass strict scrutiny, intermediate scrutiny, or even a laugh test, right? And I was being unfair to Natasha. If you actually go and listen to the argument in this case, argued last year, the attorney sucked. I don't say that lightly, but he was an attorney from Arizona at the Supreme Court, way out of his league, way out of his league. He had no idea what he was doing, and he did a very bad job. He could not give a reason why this law. And it wasn't entirely his fault because this law was awful. They should have settled this case and made it go away. They should not have appealed this to the Supreme Court. I'm sorry, well, the property owner appealed it, so I guess they had no choice. But this was a very bad case. Remarkably, the lower court ruled in favor of the city, which was horribly wrong. So they lost 9-0 at the Supreme Court. But the fact that the property owner won, the church guy won, is not significant. What's significant is how broadly the court read the First Amendment. So we have a series of opinions, concurring opinions. And we don't get this much in this class because things aren't usually that controversial. But when you have an opinion that on its face is non-zero, but there are 4 separate opinions, that means it's not really 9-0. In fact, Justice Thomas, for all of his great strengths, one of his greatest weaknesses is his utter inability to hold together a majority opinion. Very often, his 9-0s become very fractured because he takes a very strong stance on something and he doesn't usually moderate what he thinks. And that's both a strength and a weakness. So in this case, Justice Thomas, even though he had 9 votes, he didn't really have all 9 votes as together. So the first opinion was Justice Alito, Kennedy, and Sotomayor, something of an odd lineup. And they concurred. So they agreed with the majority opinion, but they added some additional words to, what would he say, further explanation, as Justice Alito framed it. Caitlin, what was Alito's point in his brief, concurring opinion?
Basically he was saying this doesn't other towns from making kinds of regulations with signs. They just can't do it.
So how, Caitlin, how could the city of the town of Reed or the town of Gilbert have accomplished this goal without imposing these sorts of content-based restrictions?
Well, the town in this case is just doing it against like non-profit and religious organizations.
Yeah, what could they have done to accomplish the exact same goals? What does Alito give suggestions?
Just doing it in a subtler form, limiting speech based on topic or subject. Oh, okay. He says rules distinguishing between lighted and unlighted signs, distinguishing between signs with fixed messages and electronic signs.
Right. So he lists a number of what are called content-neutral grounds on which the court have ruled. If they simply said all signs must be no bigger than X feet, regardless of its subject or viewpoint, that would have been fine. If they said if you can have a lighted sign in this area, but you can't have a lighted sign in that area because it may distract traffic, that's fine. If you can limit the total number of signs we put up, that would be fine, he says. Time restrictions, if they're reasonable, that would be fine. But Alito does not go on board the full opinion of expressing such a broad discussion. In fact, let's see. Only, if I do my math right, Thomas, the Chief, and Scalia. So only 3 justices actually agree with Thomas in full. So even though it's 9-0, there's not much support there all around. Okay. Justice Breyer's concurring opinion. Justice Breyer is difficult to read. He has this pedantic way of writing that tends to bore me and everyone else who reads him. His entire essence is these multivariable balancing tests. We have all these factors, and when you throw them up in the air, they somehow yield the correct answer. If you notice, no one else joined his opinion because it doesn't really do much. What Breyer is effectively saying here is he's trying to peel back First Amendment law, which is not relevant to your class, but he's effectively saying not all content-based restrictions should trigger strict scrutiny. And he effectively says in some cases the government should be able to discriminate on the basis of content. No one else joins him, and I won't dwell on it any further. Alex, what's the thrust of Justice Kagan's concurring opinion, which is really, it's only concurring in judgment. And for those of you who don't know what that means, concurring in judgment means they agree that the church owner should win, but they do not agree with any of the reasoning of Justice Thomas. Right? They do not agree with Justice Thomas's reasoning. They only agree in the outcome of the case, concurring in the judgment alone. So really, even though it's 9-0, only 6 joined Thomas's reasoning, and only 3 joined it without any sort of caveat. So it was a fairly fractured opinion, even though it doesn't look like it. So Alex, what was the thrust of Justice Thomas's opinion?
I think he says.
I'm sorry, Justice Kagan. I'm sorry, my mistake.
I think he says that
She. Yeah.
Content discrimination is a supplement to more basic analysis. In fact, in one of our first cases, and asked whether the regulation issue was interest and proportionate life.
Are you talking about Kagan now? Are you reading Breyer? I asked Kagan. That boring troll sounded familiar. It didn't sound like Kagan's Kagan's an excellent writer. She's very convivial, very friendly. It's very easy to read. Her opinions are a joy. Breyer's are not fun to read. So what did Kagan say? Do you have it? Josh?
She was on the problem with these now. She made the 2 distinctions of what the majority made in their opinion. Preserve the unintended marketplace ideas, which would prevail. And the second one is ensure the government doesn't regulate your speech based on hostility. She doesn't want to say that basically content-based regulation. That's where I get lost.
All right, Josh, let me ask you this question, right? What happens What happens if the state passes a law or city passes a law saying that you cannot put up a sign in your driveway, right? But if you want to put up a sign that says blind pedestrians crossing, you can do so, right? So usually you can't put up any signs, but say a blind person lives in the house, you can put up a sign saying blind pedestrian crossing. Is that a restriction based on content? Is that law based on the content of the sign? Except for a sign that says what? Is that based on the content of the sign? So would that law be content based? And under the majority's opinion, would that be unconstitutional? So this is what Kagan's saying. If we take this content based stuff really seriously, then any time a law is passed that tries to help some group or maybe another, it falls under strict scrutiny and can't exist. Okay, I'm actually sorry Ryan's not here because he actually asked this class last time and I was saving for him. But under the majority's opinion, the second you carve out an exception that you can allow some signs, the court will say, wait a minute, if you're carving out an exception, clutter is not really important to you, this law falls. So you give the state two choices. They can either ban all signs or ban no signs. Majority opinion basically leaves you in this weird spot where the second you start creating exceptions, well, you can't have signs except for these and these and these, it's unconstitutional. If they ban all signs, that's also unconstitutional. So you're effectively leaving the city with no choice but to deal with the clutter, right? Kagan would say, you know what, we don't need to make such a broad ruling. This law is stupid. There's no good reason why a political sign is different than an ideological sign, is different than a directional sign. Let's just invalidate this without making any more waves. And this was joined by Kagan, Breyer, and Ginsburg. Sotomayor, interestingly, did not join this part. So it's an interesting case because the majority opinion is very broad. And although there are 6 votes, 3 are not entirely there, and another 3 are not there at all. So it's kind of a weird lineup. Okay, so any questions on Reed v. Town of Gilbert? I was going to assign it in the last class. The last class the readings were enough, so I kicked it this way because the readings are a little bit lighter. But it really fits in more with the last class than today. Any questions on Reed? Okay. So let's move on to the next case, okay? The next case involves religious liberty, which is something you wouldn't think that comes up much in property, but it does. There was actually a case a friend of mine filed in Houston about a month or 2 ago where there was a church somewhere in Houston, can't remember where it was in a pretty poor neighborhood, and the city wanted to use the eminent domain power to seize the land on which the church was located. Did anyone hear about this in the news? I can't remember where it was. I think it was in one of the wards. I can't remember which one, but it was, yeah. So effectively, the city of Houston wanted to use eminent domain to condemn and take the land on which a church was there. Was there anything wrong with the church? No, but they wanted to use it for some other purpose. They wanted to do something else with the land. Yes. Yes. Houston churches sue city for taking their private property. That's exactly it. Thank you. Okay. So what if this was not a church? What if it was just a regular small business? Would there be any argument to stop the eminent domain? No. Generally speaking, if the state has a public purpose to take your land, then the only question is how much money you get for compensation. But houses of worship have historically occupied a unique place in our culture. And religion in general has been considered very special. So much so that in some respects, religious exceptions are given. So, did you guys do a common law case called Employment Division versus Smith, the peyote case? Yes? No? Yeah. Yes or no? No. Did you do a case called Bernie v. City of Flores?
Yes.
But you didn't do Smith. Okay, fair enough. I can work with that. So this is a little review. So traditionally, the First Amendment of the Constitution has a clause that says the Congress shall not prohibit the free exercise of religion
and that guarantee was extended to the states. So what does that mean? So the classic case is like this. Say you're a Seventh-day Adventist, okay, that's been in the news with Dr. Carson of late. You're a Seventh-day Adventist and your Sabbath is on Saturday instead of Sunday. Okay, you apply to the state for unemployment benefits. And the state says, well, you know what? If you want to apply for unemployment benefits, you have to prove you're willing to work. I was like, fine, great. I'll take a job any day you want. And they say, okay, why don't you take this job on Saturday? He's like, wait a minute. Saturday is my Sabbath. I can't work on Saturday. And the state says, well, you know, the Sabbath is Sunday. It's not Saturday. We celebrate, we go to church on Sunday here. It's like, listen, this is my faith. I'm a Seventh-day Adventist. Should this worker get an accommodation, a religious accommodation, that he not be compelled to work on Saturday, that he could actually get this unemployment benefits? And the Supreme Court held in a case in the 1960s that, yes, he could receive an accommodation. He could not be compelled to work on the Sabbath in violation of his faith. Okay, fine. This ruling, which may seem very congenial and friendly to you, has a very jarring implication. Based on someone's religious exercise, the law had been carved out. The law said you have to be able to work on Saturday, and the court intervened and carved out an exception to that based on a person's religious beliefs. Okay? Fast forward about 25 years to 1991. The facts of the case were like this in Employment Division versus Smith. You had a guy named Mr. Smith. He was a Native American. Part of his religious belief involved ingesting peyote. Does everyone know what this is? It's a sort of hallucinogenic cactus which is used in many Native cultures as part of their religious rituals. It's a controlled substance. It's illegal. Okay. Similar circumstances. He applied for unemployment benefits, saying, "Listen, I want to get unemployment benefits," and the state told him, "No. You were using drugs. You were terminated for that reason. You cannot claim unemployment benefits." So this goes to the Supreme Court, and a very controversial decision, 5-4, by Justice Scalia. Justice Scalia holds, wait a minute. You do not get an exception for your religious beliefs. Just because your religious beliefs require something special, you do not get an exception. The drug law applies to everyone equally. It's what's called a law of general applicability. Write that phrase down. A law of general applicability. The law applies equally to everyone. No one could do this peyote. And Justice Scalia wrote, so long as the law applies to everyone equally, the courts will not intervene and provide a special religious-based accommodation. Okay? So the Smith decision represented a departure from several decades of free exercise law. Okay? Now, why is this relevant? Well, this is relevant because it led to the enactment of something called the Religious Freedom Restoration Act. The Religious Freedom Restoration Act, or RFRA. Okay, the purpose of RFRA, among other things, was to, I want to say RFRA, R-F-R-A, it's pronounced RFRA. The purpose of RFRA was to restore the First Amendment before Employment Division versus Smith, before Justice Scalia's opinion. Okay? It effectively said if the state wants to impose a substantial burden on your religious belief, they have to prove that they have a compelling reason to do so, and that there isn't a more narrowly tailored way of accomplishing this. It's effectively like a strict scrutiny standard, right? If the state wants to burden your free exercise, your sincerely held beliefs, they have to prove they have a compelling interest and that there's not a least restrictive means available to do so. Okay, that's fine. So Congress passes this law. It's actually funny. It was actually passed by President Clinton with bipartisan support. This was very popular. Everyone said we need to give these religious organizations these rights. There was not much of a debate over this. This was the same law issue in Hobby Lobby. We'll get to that in a minute. So what happened then? The law says if a state or a city in a state violates your religious liberty in violation of this law, you can sue the city or the state in federal court. The law allowed private individuals to sue the city or a state in federal court. So what's the problem there? Have you guys seen the 11th Amendment? Under the 11th Amendment, you cannot sue a state. Under the doctrine of sovereign immunity, you cannot sue the state unless the state allows you to sue it. You can't just walk into a federal court today and sue the state of Texas if you're mad at it, right? You can only sue the state where it gives permission, right?
That's what the 11th Amendment holds. But an exception to the 11th Amendment is that Congress can waive a state's sovereign immunity. Did you do this in Bernie? Sound familiar? Congress can waive a state's sovereign immunity. So I have up here Section 5 of the 14th Amendment. Most of you never get that far. But Section 5 is probably the most important part of the entire 14th Amendment. Section 5 gives Congress the power to enforce the 14th Amendment. And one of the ways they can enforce it is by allowing private causes of action. So you've all studied Section 1983, right? Anyone ever wonder how come you can sue a federal officer or how come you can sue a state officer? That's actually passed under the enforcement powers of the 13th Amendment. As a way to combat the problems of slavery, indeed, you can, and the various resulting problems, you can sue various state officials. So what RFRA tried to do was it tried to say that if you violate this standard, you impose a substantial burden, you can then sue a state. Effectively, Congress waived a state's sovereign immunity under the 14th Amendment. Okay, Congress purported to waive a state sovereign immunity under the 14th Amendment. They allowed you to sue the state. So the question became this: could Congress in this situation waive a state's sovereign immunity? Were they allowed to? Were they authorized to? So the facts begin, of course, in Texas. So we have St. Peter the Apostle Church in Boerne, Texas. Anyone know where this is? You ever been there? I actually had a guy sat back there a couple of years ago. He actually went to that church. Not you. See, I always remember where people sit. It's the weirdest thing. He sat right where Mike's sitting, right in that same seat. So if I see people have class, I don't know who they are, but I know where they sat. It's a weird thing about teaching. So you have a church in Boerne, Texas. The church is thriving. All these people are going there to pray. And they want to expand the church. They want to make it bigger. And I have actually some pictures of the inside. I mean, it's a beautiful church. It's gorgeous. But you can tell it's pretty small. I mean, there are only so many rows. And it happened that they didn't have enough pews for everyone to sit in. And that's it's a good problem for a church to have, right? Most churches have the opposite problem, empty pews. So they applied to the city for a permit to expand the premise. The city said, no, we deem you a historical site. And because you're a historical site, you have to preserve the exterior and you cannot make any changes to the church. Okay? So if a normal business, say it wasn't a church, say it was just a shopping mall, right? Or say it was a school or something, right? Applied for a permit to expand. And the city said no. Is there any recourse? No. As we study with zoning laws, virtually every decision the state makes is reasonable. There's no way to challenge it. But the church, the bishop's name was Flores, right? Or Cardinal, whatever he was, said, wait a minute. This zoning decision imposes a substantial burden on our religious beliefs. This refusal to give us a zoning permit imposes a substantial burden on our free exercise. And because this denial of a permit imposes a burden on our free exercise, we are going to sue the city of Boerne, a subdivision of Texas, in federal court. Everyone understand so far? They relied on RFRA to say that the denial of a permit to build imposes a substantial burden that allows them to sue under the RFRA statute. All right? So the case goes all the way to the Supreme Court. And the Supreme Court decision has absolutely nothing to do with whether the denial of the zoning permit in fact burdened their religion. The only question the Supreme Court decides is whether Congress has the power to waive Texas sovereign immunity. The question is whether Congress has the power to waive Texas sovereign immunity, or if you want to use big words, to abrogate. Abrogate means waive. Whether Congress, under their Section 5 powers, can abrogate sovereign immunity. In a decision that was not 5-4, I think it was 6-3. I think it was 6-3, yeah. With Justice Stevens and Ginsburg in the majority as well. The court holds that no, that Congress cannot waive Texas's sovereign immunity. Okay, why can why can Congress not waive sovereign immunity? Okay, we go here to Section 1 of the 14th Amendment. It says, Congress shall have the power to enforce the articles of this legislation. Okay, that refers back to Section 1. And one of the provisions of Section 1 says that nor shall any state deprive a person of life, liberty, or property without due process of law. One of the liberty interests reflected in the First Amendment, the 14th Amendment, is the free exercise right. So that means a state cannot deprive a person of their free exercise rights. That's easy. But who gets to decide what constitutes a violation of free exercise? Which branch of government gets to decide what violates the right to free exercise? Congress or the Supreme Court? This is the key point. In the Peyote case, Justice Scalia said, if the law is general, right, if the law of general applicability, then it's constitutional. Congress said, no, 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 we disagree. We're going to give more protections for the First Amendment. We're going to give additional protections for free exercise. So who was defining what this phrase liberty meant? Indeed, it was Congress, not the Supreme Court. Congress was going beyond what the Supreme Court said. So the decision Bernie v. Texas, Bernie v. Flores, the Supreme Court said, wait a minute, guys. Only we get to decide what the free exercise clause means, not you. And Congress, you cannot expand the protections of the First Amendment and thereby waive state sovereign immunity. Everyone get that point? Because it's up to the court to decide the scope of First Amendment rights, Congress cannot redefine what the First Amendment means, and therefore they cannot waive Texas sovereign immunity. Everyone get that? It was an important point of Bernie v. Flores. Congress cannot decide what the First Amendment means, only the Supreme Court can. Because Congress tried to expand the scope of First Amendment rights, they exceeded their authority, and therefore they cannot waive Texas sovereign immunity and allow Texas to be sued in court. This is probably one of the most important decisions of the 20th century. This was a big, big decision. Okay. So what does this mean? RFRA was unconstitutional as applied to the states. RFRA was unconstitutional as applied to the states. Interestingly, RFRA was still constitutional as applied to the federal government. Why? Because Congress had the power to let itself be sued, right? If you want to sue the federal government, Congress can waive its own sovereign immunity. They just can't waive the sovereign immunity of the states. So you've all followed the, oh God, I can't help it, the Obamacare litigation involving the contraceptive mandate, Hobby Lobby, right? They are suing under the same statute, RFRA. Because they're suing the federal government, the suit can proceed. That's why Hobby Lobby. So RFRA is only unconstitutional as applied to the states. It's still on the books as applied to Congress. Okay, everyone get me so far? If you don't stop me, because it's a difficult point, but it's a really good Commonwealth point to understand. Okay. So what did Congress do after the Supreme Court invalidated RFRA? Well, they tried Plan B. So if the first law was called RFRA, the second law was called this. Would anyone want to try and pronounce how? Close. Anyone else? Anyone else try? Close. Yuba. So I can spell something that good. Yuba. Okay. Got that? Sure. The Religious, Land Use, and Institutionalized Persons Act. The Religious, Land Use, and Institutionalized Persons Act. Okay? This was meant to do a lot of the things that RFRA did constitutionally. So it applies to two major categories. First, institutionalized persons. That means
not just prisoners, but people in institutions, senior citizens, etc., right? How come Congress, so say if you're a state prisoner and the state violates your religious liberty, can you sue the prisoner? Can you sue the prison over it? Yes. Why? Well, in this case, virtually every prison in the country accepts federal money. All of them do. So as I'm sure you know, under the spending power, if you accept federal money, Congress can put conditions on that spending. And Congress says if you want money for your state prison, you have to consent to be sued. In other words, if you take this money, you are waiving your sovereign immunity. If you don't want this federal money, go for it. But you can't, you're not gonna get any money. So much of RLUIPA is premised on whether a jurisdiction accepts federal money. Okay. In fact, there are 3 conditions on which it applies. So first, if a state program receives federal money. Second, if some sort of state program affects interstate commerce. I'm sure you'll recall from con law, Congress has the power to regulate anything that substantially affects interstate commerce. So if the agency accepts federal money or if it affects interstate commerce, then RLUIPA applies. Okay. The final one, the one that's actually relevant to our case today, is whether an individualized assessment of a property usage imposes a burden on your religious liberty. Okay. That is, if the state takes an individualized assessment against you, something specific to your facts, if that violates your religious liberty, you could sue in federal court. Okay? This is going to be the hardest question of the day. Does anyone want to guess why, under this last category, you could sue consistent with Section 5 of the 14th Amendment? This is the hardest question of the day. Want to take a guess? If there's an individualized assessment, you can then sue consistent with Section 5 of the 14th Amendment. What did the peyote case hold? Okay, so apply that to this case. Bingo, right? If there's an individualized assessment, they're singling you out for special treatment. It's not a law of general applicability. Therefore, even under Smith, that's still a violation of free exercise rights. And then Congress can enforce that through Section 5 powers. So that's why the entire issue of this case was there an individualized assessment? If there was an individualized assessment, it is not a law of general applicability, and therefore, even under the peyote case under Smith, Congress then has the power to step in and waive the state's sovereign immunity to allow it to be sued. Everyone get that? Right? That's why there are these 3 categories, and this case falls in category number 3. Not every city accepts federal money. Not every city affects interstate commerce. Most never will. But the key point is, if there's an individualized assessment that impacts your religious liberty, then you can step in and sue in federal court. Everyone with me so far? Okay. Some more pictures of the church. Very pretty church. Yes?
This is only different from special exceptions because you're trying to see the state.
It doesn't matter whether it's a state or the city. Cities are subdivisions of states.
But just because you're trying to see the actual government.
Yes, because usually, let me ask you a question. Usually, if the state denies you a zoning permit, do you go to federal court? No. You go to state court because that's what the state created a process for you to sue in state court. But this allows you to go to federal court and sue for violation of your religious liberties. Usually, you can't do that. Brian, was your hand up? Is there another hand? Okay. All right, so everyone get that background. So it's a nitty-gritty 15-minute overview of like 40 years of religious liberty case law. But it's especially salient today more than ever. Okay, where the heck was I up to? What he's pointing at him? You're next, you know that, right?
All right, Sam. By the way, I'll get to Sam in a second. So actually, the opinion here, the Ninth Circuit's opinion is actually by Judge Carlos Belle. He's an interesting guy. He was actually on the Spanish men's national basketball team. He's huge. He was an Olympian. He's also an aristocrat. And he's a really cool guy, but interesting that they picked his opinion. All right, Sam, what were the facts in the Guru Nanak case?
Basically, the Sikh society wanted to build a temple.
And Sikh, by the way, it's a religion, it's a faith. Please don't know, but yeah, so go ahead.
The place they wanted to build it was in a low density residential area, so they had to get a conditional use permit.
Okay, go one step at a time, right? So where was the first location that they wanted to build their temple? Basically in the center of the city, right? In that area, could you build, in theory, a church or a house of worship?
You could if you had the CUP.
Okay, remind me, what's a CUP?
Conditional use.
Okay, conditional use permit or special exception. What does that mean? We did that from last class, the class before.
Special exception.
Yeah, what does that mean? What's a conditional use permit, special exception, same thing. What does it mean? Who drafted the CUPs? Okay, good. So ever remember the difference between a variance and hardship? Mike, what's the difference between a variance and a hardship? I gave you the answer. A variance and special exception. Sorry. Yes, I'm sorry. I gave you the answer. I often do that. I'm sorry. So, difference between a special exception and a variance. Go for it.
Like I said, variance involves an undue hardship that could be
Good.
redressed, and I guess in a special exception, wasn't necessarily an undue hardship, but it was, I guess, still had a good reason.
Under what circumstances, Mike, is a special exception granted? Cameron, you got it?
Special exception.
Under what circumstances is a special exception granted? This you guys have to know.
If you don't have a use that conforms to the zoning laws.
No.
You have a prior.
No. Kaylor, do you not remember? Jessica? Haley? I'll come back to you guys who didn't know. Me, what requirements? They're not the zoning board's requirements. Who creates these requirements? This is an important point. The legislature. Okay? The important point is this. The legislature, the city council, whatever it is, right? They will create what's called a special exception or conditional use permit. It says, usually you can't build a church here, but you can build a church here to meet X, Y, and Z conditions. If you take care of noise, you take care of traffic problems, and you have enough space so that there's no congestion, right? That's effectively saying, under normal circumstances, we're not going to let you build this here. But in a specific circumstance, we'll give you a CUP. We'll let the zoning board check off. So, Cameron, in this area, in the first area, the residential area, could they have gotten a CUP to build the church in that area?
Yes, they could have. I think that they said there were other instances where there were allowances for where churches and temples were only conditionally permitted to use residential districts through the use of the CUP.
Exactly. Okay. Everyone understand this? It was possible to have in the residential district the CUP. And indeed, the discussion says that the planning division recommended giving them a CUP. Kaylor, do they get their CUP in the first area? How come? Yeah. This is always the reason why things are denied. They say, if we build something new, there will be more noise and more traffic. Okay. That will be true in 100% of situations. Whenever you add more people to an area, by definition, people make more noise and more traffic. It's inconceivable not to have this happen. So this is a standard excuse. Yes, sir. Oh yeah.
That's exactly.
What held up the Ashby high-rise for a number of years was there was concerns it would create too much noise and too much traffic. Now, the standard in Houston was whether it would create, it's fluid, but not any noise, but too much noise. And they actually had certain measures that would help eliminate noise, help eliminate traffic. But that held the Ashby up for a number of years. Okay, so the first site, the residential one near the center of the city, they were denied the permit. Okay, then Jessica, what happened next? Where was this second area located? Yeah, in the agricultural, so basically out in the country, right? And could in that agricultural area, could a church have been built under a CUP? Okay, again, that's right. They could have gotten to seek another CUP. And Jessica, what kind of conditions did they ask the church to make when they were considering the CUP? What kind of like stipulations or what kind of requests did they make? Mm-hmm. Ravashi, what conditions did they ask the church to comply with?
They asked them to make sure that it was limited to 75 people.
Good.
That all the spread, that we had indoors,
Good. They were trying to take measures to mitigate or to reduce the risk of sound and noise. And Ravashi, did the church, or sorry, did the temple agree to all these conditions?
Yes.
Okay, so they agreed to all these conditions, right? And after all this, the planning division granted their application. They actually approved the zoning permit. What happened next, Rachel? After the permit was approved?
Well, the neighbors.
Yeah, the neighbors complained, and it was actually the neighbors that appealed. And then what happened after that, Rachel?
Well, board of supervisors, all members, people, and had the application.
Yeah, and they said, you know, we have to protect the right to farm. We have to protect agricultural concerns. You know, we don't want, we don't want this here. Now, Aaron, what's this business about leapfrog development? What was that about? Oh, good. I'm glad.
Development referring to as urban sprawl.
Yeah.
And a requiring extension of public facilities.
Yeah.
Additional services extended on the periphery of the existing urban areas.
Good,
or an
good.
extension not provided.
Good. So effectively, it works like this. You have a lot of stuff in the city, and then you leapfrog out to the country of other stuff there. What about all this room in between? Now, this is why this case annoys the heck out of me. Aaron, did they want to build the church close to the city? Were they allowed to? So here's what happens. They want to build it close to the city. They can't. They try and build it far away so there's no noise or traffic. They say, oh, that's too far from the city. Everyone see the catch-22, right? If you're too close, oh, too much noise and traffic. If you're too far, oh, you're going to hurt the farmers. And you're too far from everything else. They're effectively making it that they could not build it almost anywhere. All right? But one point just to dwell on, Dagny, is that exactly right, though? Could they have actually built it in a third or fourth, fifth place? It would have been possible. Yeah. And in fact, in the footnote, they actually say that the city was willing to help them find the location, although I don't know how seriously you want to take their representation. So from that, in a normal circumstance, right, say they weren't building a church, say they were building a restaurant, right? And the city said, you can't build a restaurant here, you can't build a restaurant there. Would the restaurant have any recourse to sue in federal court? What would the restaurant have to do? Think of the case we had last week from Issaquah, Washington. Remember on the street where they said, make it this color, make it that color, right? What's the only remedy when you have a zoning board being unreasonable, usually? From what court?
Yolanda, remember? What kind of court were they suing in? I'm sorry? In which jurisdiction? State or federal? Why state court? The state sets up the state courts where they say you can sue in state court if the zoning board is being unreasonable. You can't walk into federal court and allege a violation of constitutional rights. Okay? So Yolanda, what did they do then? What did the Guru Nanak temple do? No, they did not appeal. What's the case we have here? I mean, yes, they ultimately appealed it, but where did they sue? Where is this case from, the one you're reading? Yes, flip back to the first page. And where in the Ninth Circuit is based in California, in San Francisco. Where would a case be appealed from to get to the Ninth Circuit? No. How do you get to Federal Court of Appeals? We have 3 tiers of federal courts, right? At the top, you have the U.S. Supreme Court. The U.S. Supreme Court hears appeals from both state Supreme Courts and the federal courts of appeals. Okay. Below the federal court of appeals are the federal district courts. Okay. Federal district courts are the federal trial courts. For example, we are in the Southern District of Texas. That's where federal court in Houston is. So Yolanda, the person filed suit in federal district court in California. Okay. And what claim did they bring?
I guess they didn't really have restrictions weren't there.
What statute did they sue under? That funny name. I'm sorry? Yeah, right. Yeah, they sued under Yuba, okay? And the church, you say church, I'm sorry, the temple argued that it would violate the religious liberty. It imposed a substantial burden that they could not get their building permit to construct their temple. Okay? And the first issue, the threshold issue, and we discussed why, but in order for this to comply with the peyote case, right, in order for this to be a instance where you could actually have Congress allowing the state to be sued, there has to be an individualized assessment. It can't be a law of general applicability. Okay? So Eduardo, was there an individualized assessment in this case? What was the individualized assessment here? Do you know what individualized assessment means?
Yes.
What does it mean?
Well, I understand that it means that it applies specifically to the
Yes. So, was the application, the conditional use permit, specifically designed for the church in this case, or the temple? Chris?
No, like every board member had different reasons for why.
No. But that goes the other way, right? Was the application of the CUP in this case specific to the facts of the church's case? On what grounds did the temple have its permit denied?
Very,
What are they?
they were different for every person.
Does that mean there's an individualized assessment?
Yes.
Why?
Because it wasn't strict, it was
Close.
an opinion. I mean, well, different.
Alex?
It was under circumstances of a particular case.
Yes, that's what the court says. The court says it was done on the circumstance of the particular case. Each case was handled differently. Conditional use permits were handled differently for each state, for each case.
As a result, this was individualized assessment, and you fall under the third category in RLUIPA. Okay. In contrast, let's say there's a statute that says, go back to Alex. Let's say a statute says you need to have a minimum lot size of 20 acres, and you only have 19 acres, and they deny you the permit. Is there any sort of individualized assessment there?
No, that's pretty typically up.
Right. So some zoning laws are very mechanical. They apply automatically. Those would not be individualized, and you cannot drag those into federal court, right? RLUIPA was not meant to be a blank check for anyone to go into federal court to sue the state. It was only meant for specific actions taken that may burden a religious liberty. Okay. Now, Ryan, why do you think zoning decisions affecting religious institutions may have a special place in court, as opposed to a zoning decision for, say, a restaurant or a bookstore or whatever else? Why? What could be going on here? Why could a city decide not to allow the construction of a certain type of religious house of worship? Right. So does everyone remember the Ground Zero Mosque? Remember reading about this some years ago? What's it called? Park 51. I can't remember the name of it, right? So effectively, a group wanted to construct a mosque a couple blocks from the World Trade Center. This created a serious uproar. And people said, no, we can't have this here. We can't give them the permit to build, right? Now, what was the rationale for this? Well, the stated rationale is, oh, we have a historical site. This building is historical. We can't have them change the exterior. And that this tile, and I'm not joking, that the tile used in this building is very historical. They come with all sorts of legitimate sounding rationales. But, we're adults here. A lot of people just didn't want a mosque near the World Trade Center. Straight up, to use your phrase, they didn't want it there. Is that a legitimate ground on which to deny a zoning permit? Under New York law, I don't know, but under RLUIPA, there'd probably be a problem there. Okay. So the reason why this statute exists is to allow a rare intervention in federal court, where a zoning decision is based on a specific assessment of property law. It's a rare case. So most of the time, zoning disputes stay in state court, and you can't bring them to federal court. Okay, everyone with me so far? All right, so the question becomes one like this, right? RFRA has a couple elements. And it works like this. So you cannot impose what's called a substantial burden on religious exercise unless two factors are met. First, it's in furtherance of a compelling governmental interest. And second, it's the least restrictive means of furthering that interest. Right? What does this mean? If the state wants to impose a substantial burden, right, on your religious beliefs, and here the court finds indeed there is a substantial burden, telling this group that they cannot build their temple, their house of worship, is a significant burden on their faith. Everyone see why, right? If you can't have a house of worship, it limits your ability to believe. This is similar to in Boerne, Texas, where they want to expand the church to hold more people. This is even worse than this. This is not about an expansion. This is about building a temple in the first place. Okay? So is there, in fact, a compelling interest here? Right? Tyler, is there any sort of compelling interest to keep this temple from being built? There's none. What could be the compelling interest here to not allow this place to be built in the middle of the country? Traffic, noise, pollution. Okay? So the key word here is compelling. So, I mean, Tyler, does the government have some interest in getting rid of noise, in getting rid of, traffic? Do they have an interest there?
It does have an interest.
Is that interest compelling?
In this case, it's not, because there wouldn't be the traffic and noise.
Yeah. By putting the word compelling in here, The statute gives the federal court the power to judge how good is a state's interest. In virtually all circumstances that we've studied, the courts are not going to second guess whether there's actually an impact on noise. The courts are not going to second guess whether there's an impact on traffic. The courts will not second guess whether this will decrease property values. But by putting the word compelling in there, that means it's got to be a damn good reason. They have to prove it. Merely saying we think there may be more traffic ain't going to cut it. Because religious liberty is so important under this statute, you cannot use a general excuse of traffic to suffice. And in fact, the city has no compelling interest whatsoever. Okay? Everyone will get that. So the holding, right? The holding of this case asks first, is there an individualized assessment? The answer is yes. Second, they ask, is there a compelling interest that can justify the substantial burden on religion? And the answer to that question is clearly no. There's maybe an interest in traffic and pollution, but that's not a compelling interest. It doesn't rise to the level of the highest order that would justify such a significant burden on the religious beliefs of the Guru Nanak temple. All right, any questions on the first case? You have a nice brief introduction to sovereign immunity law and common law. By the way, people all say, oh, I want to be a Texas lawyer. I don't care about federal court. What do I care about federal court? So the interesting aspect of federal courts is if you want to be a state litigator, your number one job is staying out of federal court. Just as important as getting into federal court is how to stay out, right? How to make sure your parties are not diverse so that they can't get diversity citizenship. There are various ways of making your case unremovable. And if you want to do only state court litigation, trust me, take federal courts. It's such an important class. Not enough students ever take it, but you really should. Now, I don't teach, by the way. I'm not plugging my class, but take federal courts. It's a significant case. All right, any questions on Terre? I'm sorry, on the first case? Okay, so let's move on to the second case called Village of Terre versus Boraas. Terre, New York is a small town in Long Island that's basically 1 square mile. And it's near the State University of Stony Brook, which is a state school in Long Island. So to understand this case, here, how to put this nicely, you have to understand hippies, okay? I'm not saying this lightly. In the 1970s, there were these things called communes, where basically groups of hippies lived together, collected food stamps, and pissed people off. I'm not joking. Lots of laws were passed to make it harder for hippies to congregate. It's like an Eric Cartman statute. I'm not joking. So there's a case mentioned in your book called the United States Department of Agriculture versus Moreno, USDA versus Moreno, where basically they passed a statute trying to deny hippies food stamps because they all lived together. They didn't work, so they were poor. And they tried saying if you had unrelated people living together, they don't get food stamps. The court invalidated that. This case is a follow-up. So again, this town of Village of Terre was not too far from the State University of New York, which had a lot of hippie college students. And the state passed this ordinance, which was meant to make it impossible for unrelated people to live together. Notice, this wasn't a law banning fraternities. Those were allowed, right? This wasn't a law banning sororities, right? You could have those. This was specifically in this small town. They didn't want these college students living there, paying rent for one person, then moving like 8 people in, okay? This is actually a sign. I had a friend years ago who traveled around the country. They actually took this picture of the sign of the Village of Terre, and so the ordinances prohibit basically everything. Alcoholic beverages, lotteries, soliciting. Basically, you could do anything fun, and including living together. So let's go to Eric. Eric, what was the statute that the Village of Terre enacted?
It limited the residence to single-family home related by.
Okay, so if you're related by blood or marriage, is there a limit on the number of people who can live in a single home? No.
Oh wait, no, not the number of people.
Yeah, so if you're married or if you're related by blood or marriage, a marriage of sanguinity, if you want to use a fancy word, right? If you're related by blood or marriage, is there any limit to the number of people who can live in a house? No. Okay, this is important. If you are if you're married or related by blood, you can have as many people as you want. If you have the Brady Bunch with 8 kids, that's fine. Okay, but what happened, Eric, if people are unrelated? What's the limit?
That was it 5?
No, it wasn't 5.
Can't remember. There were 6 of the people.
5 makes the drum circle too many.
2 living and cooking together, a single house. And
2. So effectively, I can't do this in my night class. So, I think Robin Williams once said, if you remember the 70s, you weren't there. I don't remember them at all. So if you had more than 2 unrelated people living in a house together, they couldn't. So 2 or more, no good. You only have 2. As the fear was in this case, you had one person move in, and then another person moved in, and then like 3 more people moved in. There were probably more that they don't know about, but they were kind of hanging out in the between the walls, right? So they were there, and the city brought a criminal prosecution to effectively kick them out. Now remember, this was a town of 700 people. It was a small town, so it probably wasn't very difficult for them to figure out that there were all these people staying in this home. So they filed suit in federal court, and they sought to invalidate this ordinance. So one thing that's important to know about this case is, believe it or not, this was the first time the Supreme Court had a major decision on zoning since Village of Euclid. Village of Euclid was, what, 1926 or so? And this is, what, 1970 something? Basically 50 years elapsed without the Supreme Court looking at zoning. And you recall in Euclid, the court basically said, we're not in the business of second-guessing the legislature. These apartment buildings, parasites, right? If the state wants to get rid of them, let them get rid of them. This same ethos, this same philosophy inspired the court's decision in Terre, right? Catherine, what did the court hold in Terre?
The Supreme Court?
Yes, Supreme Court.
Okay. They held that it was unconstitutional. They overturned it.
No, they didn't.
Shoot.
No, they upheld.
Oh, they held it was valid. I apologize.
Yeah, so why?
They said that it was that the government interest was legitimate.
Was illegitimate?
Was legitimate.
Was legitimate.
To have a quiet place where yards and not overcrowding. Anyway, they said that was legitimate, and that no fundamental rights were trampled basically by this one.
Okay, good. So the court upheld, and actually the vote was 8-1, wasn't even close. The court upheld the decision. And they said, listen, the public welfare, right, the police power, the welfare, this is very broad and inclusive. And the court writes, this is Justice Douglas, it's within the power of the legislature to determine that the community should be beautiful, healthy, spacious, clean, well-balanced, and carefully patrolled. That the general welfare allows them to decide to make things beautiful, right? Does it matter? Does it matter that this impacts individuals living together and familial relationships and a right of privacy? And the court says no. Okay? This is an interesting point that I want to dwell on for a moment. This was in the 1970s, and you may recall from con law, there were a lot of crazy cases from those years. Rights to contraceptives, rights to abortion, this and that. What about property? Where does property fall on the list of constitutional rights? Is the right to property and live with whom you wish a fundamental right? The court says no. The court says no. If I may, if you recall a case called United States versus Caroline Products with a famous footnote 4, where the court purported to say that, fundamental rights get this heightened scrutiny, but non-fundamental rights get nothing. Get the rational basis, right? This is a crock. The court can't decide which rights are good and which rights are unimportant, but they do it all the time. And the court has consistently held that property rights are second-class rights, notwithstanding the fact that it's right there in the Fifth Amendment. It says you can't take property without compensation. So the court said this is not a fundamental right.
We apply a rational basis review, and we're not in the business of policing these sorts of things. Okay? The state can have quiet and seclusion, and this is not within the power of the courts to correct. Again, this was an 8-1 vote. This was the I don't want hippies to live in my neighborhood decision. It's interesting. They allowed the hippies to get food stamps, but they didn't allow them to live where they wanted to live, which was a weird. The cases were back to back, one year after the other, which is somewhat odd. Any question of the majority? Josh, what did Justice Thurgood Marshall say in dissent?
He went First Amendment route, talked about freedom of association.
Is there? Hold on, I got it up here. I scroll up. Josh, is there a freedom of association in the First Amendment? Right there, you can read it. It's only a few words. Is it
No, peaceably assemble.
Is that association?
No.
Okay, so the court effectively made up the right of free association. It was actually a case called NAACP versus Alabama. The facts were like this. The state of Alabama demanded that the NAACP turn over their membership rosters. Right? They said all corporations must turn over their membership rosters. This was an intimidation tactic for sure. And the court said, no, you have the right to free association. You don't have to disclose who you associate with. So the court kind of fashioned that out of whole cloth, one way or the other. But Justice Marshall builds upon this and says that you have the right to live with whomever you wish to live with, right? You have the right to establish your home. You have certain emotional needs are established in your home, and you have the right to be let alone, okay? That's all good stuff for con law. But then he actually goes to the heart of the matter and says why this statute is not even rational, right? Jack, what about the statute is really irrational? The way they justify their interest in protecting quiet. This is the more important part.
I mean, where he talks about compelling and.
Yeah. What's the state's compelling interest here?
So I think he's saying.
But right over here, what is the state's compelling interest here of keeping this ordinance in place?
I mean, they just.
What's always the interest?
Promote police powers and promote.
And specifically,
Safety. Even like.
More specific. Was it always in every case? What are they trying to preserve? Noise and traffic, right? You're sensing a pattern. In every single case, the state's interest boils down to noise and traffic. Okay, Jack, does this ordinance actually go about limiting noise and traffic in any meaningful way? Why not?
Because they have fraternity houses, all that other stuff.
What if you're a family with 8 kids and each kid drives? Is that going to be a lot of noise and traffic?
Yes.
Is there anything in the statute prohibiting that? What if you have 2 hippies with bicycles? I'm sorry, 3 hippies with 2 bicycles, right? It's not practical. Are they making any noise? No drum circles, right? Just bicycles. Right. So Justice Marshall says, listen, even on its own terms, this statute doesn't work. If they were actually interested in getting rid of noise, right, they would limit the number of people who live in a house, or maybe the number of cars that can be licensed in a single home. But by targeting the number of people who live together and not anything to do with noise, it's obvious that this exemption is discriminatory, right? In the same way that in the first case today, they allowed these types of signs, but not those types of signs, it means that clutter wasn't really the interest. Here, the fact they allowed lots of big families, but not the small hippie homes, suggests noise was not the real reason. He's applying a heightened form of scrutiny, which probably resembles strict scrutiny, that they're questioning the motivations of the state, and they're effectively saying the state does not have the compelling interest they say they do. Okay? This is inconsistent with Euclid, no matter what he says. It's inconsistent with Euclid. I agree with it, right? I think courts do have a capability and indeed a competence to assess whether a zoning law is based on reality or BS. I mean, you guys have been in this class for a couple weeks. Noise and traffic in every single case, it's baloney. It's never the real reason. They're trying to keep out something they don't want to be there. They want to keep out the hippies. They want to keep out the church signs. They want to keep out the Sikhs. Yeah. They want to keep out the Sikhs because remember, there's already one, their Sikh temple. They want another one. And that was in fact the case. So when you're dealing with these sorts of familial, religious speech rights, courts do indeed have the competence to look at it with more scrutiny. And Justice Marshall basically said the statute is under-inclusive. There's no limit on the number of people who can live there. And this does not satisfy constitutional scrutiny. And he would have voted to invalidate it. But he was but one dissent. Any question on Justice Marshall's dissent? Nothing? All right. There was actually a note case I want to mention for a little bit afterwards called Moore versus City of East Cleveland. And this case was actually a little bit more difficult. Effectively, the city was trying to promote nuclear families. And the way the law was drafted, you can't have more than one set of grandchildren living in a house. It's crazy, right? Why would the state care? So you basically had a grandma who was living with grandsons from two different children, right? Grandma living in a house with two different children, right? The city actually prosecuted her for violating the zoning ordinance, if you can imagine, for a grandma living with two different sets of grandkids. And in a 5-4 decision, this was 5-4, the court held that this prosecution was unconstitutional, right? The state has interest in noise and all this other stuff. When they start chopping up and slicing a family, these families are okay, these are not. They intrude on various due process rights involving familial privacy. Okay. All right. So any questions on the East Cleveland case? It's a little footnote, but it carved out a big exception for the Village of Belle Terre ruling. No? All right, so what do we have today, right? In certain cases where a zoning decision impacts speech or religion or familial autonomy, courts start applying more scrutiny, right? In the Guru case, we see that when a religious liberty issue is involved, the courts step in. In the Reed v. Town of Gilbert, when you start discriminating on the basis of messages, the courts step in. And even in Moore v. Cleveland, when you're actually intervening with the decision of how families are structured, courts step in. These are the outliers because in virtually every single situation, courts, and particularly federal courts, do not get involved. They do not want to sit as appeal courts for the zoning board, and they will let the democratic process play itself out, relegating property rights to a second-class, insubordinate right. Any questions? I will see you all on Monday. Have a great day.